Today I've got an exclusive story for you because it's about me. Well, my channel here anyway. You might remember a good few weeks ago, actually on the 15th of November, I released a video called Viral Video, the 5-year-old cyclist. You might remember that as the video where the father was riding behind his child on the bike and the oncoming car failed to stop and the boy came very close to the oncoming car, but the father told the boy to continue anyway. So I did a bit of an analysis of this video. In short, I said that the vehicle should have stopped and the vehicle was in the wrong, but also that I felt that if I was the father, I wouldn't have allowed the child to go forward. Anyway, that video was some 9 minutes of legal commentary and analysis, and the thumbnail caption was "Who is to blame?" The reason for the thumbnail caption "Who is to blame?" is because that was the debate that was going on between Jeremy Vine, Sajid Javid, and frankly, half of the internet, because as the title suggested, this video went viral. So my channel received a copyright strike for that video, and that's what I'm talking about in this video. So welcome back to you 250,000 loyal followers but if you are new to my channel and you're yet to hit that subscribe button, do it now, because I'm a barrister who helps you understand law. And in fact, it's that devotion of mine, this daily devotion to demystify the law, to bring stories to you, to bring my thoughts and analysis to you. It's not always going to be something you agree with, and that's something we're going to touch on in this story here. Because as lawyers, we very often tell clients, and other people for that matter, things that they don't necessarily want to hear. Now, typically you might expect that if you go to someone for advice, they are going to tell you how to do something or why you are correct and fight your corner, as many people put it. However, that's not quite the whole of the story. What a lawyer will very often do is look at the case as a whole from both perspectives, both your perspective and the oncoming perspective, pun intended this time, so that a lawyer can advise on the strengths and the weaknesses of a case or a situation or whatever it might be. And that is precisely what I did in this video. I took a very neutral, objective view of this video and gave my views and my thoughts of exactly what was going on here. Now, I'll link that video in the description below so you can go and watch that. It includes the clip, which is why there was a copyright strike against my account, because there was a complaint filed that it was a breach of copyright. Spoiler, it is not legally a breach of copyright because I'm offering education, legal analysis, it's news reporting, so ultimately it's fair use in one of a number of different ways. But to hear exactly what happened, make sure you watch till the end of the video. So as I said, this video was released on the 15th of November. And all was fine. It received about 50,000 views, in fact. So I was quite pleased in that 50,000 people had watched my video and got some useful insight, hopefully, I would humbly suggest, in the safety of using the roads, ensuring your children are safe, and to other vehicles to please make sure you drive safely. But also to parents that you don't allow your children to ride in the road where you know it's going to be dangerous. Because obviously the child could sense that the vehicle wasn't going to stop, or perhaps the child was afraid of the oncoming vehicle. One way or another, the child had asked whether he should pull over to the side of the road. Anyway, on the 29th of November, I receive a dreaded email, and it is a dreaded email for any YouTube creator. Subject matter: your video has been taken down from YouTube, and then the title of the video, Viral Video, the 5-year-old cyclist. The body of the email reads, "Due to a copyright takedown notice that we received, we had to take down your video from YouTube." And then the title of the video, the URL, "This means that your video can no longer be played on YouTube. You received a copyright strike. You now have one copyright strike. If you get multiple copyright strikes, we'll have to disable your account. To prevent that from happening, please don't upload videos containing copyrighted content that you aren't allowed to use." Now, for most YouTube creators, this is quite a devastating email. However, as you've probably gleaned from my spoiler a little earlier on, I did manage to resolve this because, as I said, this video was not in breach of copyright, it was fair use. So this is the legal explanation that I'm weaving into this video, into this story, because when you use material where the copyright belongs to somebody else, you need some kind of reason to be able to use it, and this typically is fair use. Fair use can include analysis and criticism. It can even be parody and pastiche, where it's an obvious comical version of the original. Now, for my part, I was obviously offering legal commentary on the issue, which comes under education, it comes under criticism, it also comes under reporting, because it is obviously a newsworthy event, mainly because the news of it was fairly widespread, but also my channel here, with 250,000 of you subscribing, with millions of people watching this channel every month, it is sort of newsworthy. But my channel wasn't the only channel that had a takedown request filed either. I have permission to tell you that Ashley Neal's channel also had a similar takedown notice filed against his channel for his analysis from a professional driving instructor's point of view, making comments about the video as well, and his video was removed and he also received a copyright strike. Anyway, and as you probably further gleaned, that's not the end of the story. You see, when you receive a copyright strike on YouTube, you've got a number of options. Fairly limited options, but you've got options. But before I go into those, I'm going to tell you about YouTube's perspective, because lots of people get very frustrated with YouTube about copyright takedown requests. Many of them deemed to be illegitimate, frivolous, vexatious, and simply plain wrong. However, looking at this from YouTube's perspective for a moment, if YouTube as a platform is hosting a video which contains material which may have copyright infringement within it, then YouTube has a legal obligation towards the copyright owner. Now, if YouTube receives a legitimate takedown request on the basis of copyright infringement, then YouTube must act. And in doing so, YouTube will 1. Take down the video, and 2. Apply a copyright strike to the channel. One of the reasons for the copyright strike is so that YouTube can sort of police and monitor channels that repeatedly infringe copyright, so that they terminate those channels so they don't continue to infringe copyright. However, whilst there is an obligation to take down a video that is infringing copyright, there is also another obligation upon YouTube to comply with a legitimate request to have said video reinstated. This is called a counter notice, and that's one of the options. But before we get too far into the counter notice and what that means, one of the options is, of course, to contact the person that's filed the complaint. So that's exactly what I did, because as a lawyer and a mediator, I always take the approach that it's better to be nice, it's better to try to resolve things without any kind of formal filings and all that sort of stuff. You might be very surprised to hear that we as lawyers will very often recommend against formal proceedings because it's quicker, it's cheaper, you've got more control over it, and all these sorts of things. So that's exactly what I decided to do, and I sent the following email. Dear sir, I've received the notification of your complaint against my video resulting in a strike. I'm not sure whether you watched my video in full, but I always aim to provide a balanced view in respect of videos upon which I comment, especially road traffic videos, to encourage road safety for all road users. I took the same approach when I commented upon your clip, and I absolutely agree with you. The car was very much in the wrong, and both you and your son have every right to be on the road. As a barrister, I must also comment upon the safety aspects of the close proximity between your son and the other car to highlight the risks and dangers to my viewers. I can assure you that no insult or offence was intended against you in the views I expressed, and I would be very grateful if you would retract the copyright claim. I am willing, without prejudice, to remove the video from public view if you do so. I have a vibrant community on YouTube and provide free legal guidance to millions of people each month, many of whom have had very positive results having watched my content. I sincerely hope you will see the positive nature in which my channel is intended and agree to my request. With best wishes, Daniel. The copyright owner did reply to my email to the effect that they had watched my video, took no offence, but maintained that it was a copyright breach and therefore would not remove the copyright claim, therefore it would not retract the copyright strike. Therefore, per the rules of YouTube, I was left really with only one option, which was to file a counter notification, which is a legal request to YouTube to reinstate the video on the basis that I disagree that it's copyright infringement and that I have a reason to be using that video. And if YouTube deemed that my counter notification met the minimum requirements for a counter notification, then YouTube would forward that on to the claimant and allow them 10 US business days within which to file a court claim to keep the content off the platform. If you want to know more about the precise wording I used in the counter notification, please head over to the Art and Media Law by BlackBeltBarrister and Alan Robertshaw channel linked in the description below. Yes, it rhymes, I know, it trips off the tongue. So you can head over there and we will be doing a follow-up video talking about all of the issues of copyright, how to fight these things, and how to word up one of these counter notifications. And we'll put up the exact wording that I used within this counter notification so that if you happen to be a YouTube creator, you can make use of it as well. You can get an idea of how to approach these things as well, so that if you have a valid reason to be using copyrighted material, which comes within the remit of fair use that you'd be prepared to defend in court, then you can obviously glean some guidance from my counter notification. Because ultimately, that's what this meant. It's a notification that I am countering the claim to copyright on the basis that I believe that I'm using it under fair use, and I'm prepared to defend that position in court. That's ultimately what it means. So then, of course, if the claimant to a copyright takedown request does wish for that content to remain offline, then they have the opportunity to file a claim for the same in court, and then obviously it will be decided in court. The third and final option for these copyright strikes is do nothing and wait it out. And it stays on your account for 3 months and then disappears. So now a brief discussion on the copyright law itself, because hopefully this will clear up a lot of confusion that a lot of people might have. I've heard of views where if something is in the public domain, then everybody can use it, and therefore there's no copyright infringement because it was in the public domain. That's not quite true. But the reverse isn't true either. Just because it's copyrighted by somebody doesn't mean that nobody can use it. There are certain things that are restricted under copyright law, which is the CDPA, the Copyright Designs and Patents Act, which does protect the rights of the copyright holder, which is not necessarily the person that filmed it. You see, copyright is a really interesting subject. The first owner of copyright is generally the author, but even then it might depend if the person is employed, because if you're doing it in the course of employment, then your employer will generally be the first owner of copyright. But one of the trivia questions might be, perhaps over Christmas in some kind of trivia when you're all discussing interesting trivial things, you might ask your family around the dinner table to vote who owns the copyright in a photograph. Is it the person who's having their photograph taken, the person holding the camera and presses the shutter, the person that owns the camera manufacturer, or the person that ultimately develops or edits the photograph when it's on a computer or coming off film? Now, as always, if you know my channel well enough by now, there are several different aspects to this. The very simplest one is it's the person that actually presses the shutter, because that is the person who's used some kind of skill or lack of skill. They've used their own creativity or lack of creativity to make this photograph by pressing the shutter. However, if they then hand that, let's say, raw footage to someone else who is a professional photo editor, and they do some wondrous things with this and produce a different version, then there are two copyrights that exist, one on the original photograph and the second on the new photograph that's been produced, presumably with permission. We call that a license to do something with the copyrighted material, which is one way that other people are allowed to use copyrighted material, is by a license. You can also assign copyright, which is giving someone else the rights to that copyright. So a license will be limited in some sense. It might be limited in time, it might be limited in scope, it might be limited to whom you can present this copyright. But also, as I said, there are various defenses to copyright as well, which include the fair use, which is criticism, includes news reporting. It might be comedy and pastiche, which is, as I said, something which is obviously meant to be and designed to be comical, but is otherwise using what would be copyrighted material, but it's a specific defense under the legislation. So all in all, it took me 2 weeks and 2 days to get this copyright strike resolved and removed from my channel, which it was in the early hours of this morning. I also understand that it's been removed from Ashley Neal's channel as well. I will also link to his video where he gives his analysis on the same clip in the description to this video, so you can head over and watch that as well if you wish. So ultimately, as per my email to the claimant, if it really was that they were upset about the content, I did offer and I would have taken it down. But they assured me that no offence was taken and that it was only because they believed it was a copyright infringement that they wanted it taken down. But in my view, and as per my counter notification, it isn't copyright infringement for all the reasons I've outlined in this video. But anyway, I thought I would share this story with you because this is one of the many difficulties that we as creators have when bringing you this content, which does take a daily toll around work life, and family work life balance and so on. Very often I'm up in the early hours of the morning recording these videos, which is why you see me in big fluffy fleeces to keep warm in the early hours of the morning. I record these, I stack them up to go out daily, so hopefully you get daily content. But this one I am recording now on the day of. Whether it gets released today or not, I don't know. It depends how long I have left in the day to do this. But I thought I would share with you the difficulties that we have facing these complaints, facing these claims, and in this case, facing a copyright strike, of which we can only get 3 before the channel is entirely terminated. But that's why I was and I am willing to fight these things and go to court if necessary, because I firmly believe that what I do on this channel is to demystify the law for you, to help give some legal commentary. You may not always agree with it, but that's sort of the point. You may not always agree with and you may not always like what a lawyer tells you, even if you go to them for formal advice, which this is not. But even if you go to them for formal advice, you may not like what they say, because I would say at least half of the time is giving clients advice that they don't like, because parts of their case are weak sometimes and they may lose. And there are times when we have to tell a client, you will lose, or you will very likely lose. And some cases might be absolutely clear cut, where we will ultimately say this claim or this defense must fail. Some of those cases are very black and white, letter of the law. If this is not done, then you cannot do this, or this is wrong because of this. And sometimes when there's no way out, yes, we have to say something that someone doesn't like. But anyway, I digress. That's just one of the things that we have to deal with as creators on YouTube. So I'm pleased to announce that it's been resolved. The video is reinstated. I will link that in the description below. It hasn't received many views yet because it's just gone back live again. So please give that video some love. Let me know your thoughts and comments on it. You might have wondered why it disappeared. The strike has also disappeared and my channel is once again in the clear. So thank you all for your support, particularly on Twitter, those of you that join me on Twitter to retweet and get YouTube's attention. Ultimately, I just had to follow the normal legal procedures to file this counter notification. As I said, if you want to know more about the counter notification, go to the channel linked in the description below, Art and Media Law by BlackBeltBarrister and Alan Robertshaw. I'll see you over there for our new video when we discuss the exact content of this counter notification. I hope you'll find that interesting. I hope you found this interesting. Please remember to like and subscribe, and I'll see you next time.